Assalamualaikum warahmatullahi wabarakatuh and salam sejahtera. I'm Asma binti Maisa. So today I would like to present my second individual assignment for case of law on industrial relation for subject industrial relations, regulation and cyber security INC 500. Okay, the case is between Menteri Sumber Manusia versus John Hancock Life Insurance Malaysia Berhad. The case number is W0122 of 2003. The gist of case is about the Industrial Court Award Certiorari. Okay, let's begin. So this is my presentation outline. First, I'm going to describe the facts of the case, issue of the case, judgment of the case, analysis and critics, and also last but not least is reference that I used for this particular assignment. So the background of the case begin when Mr. John Kim Hong accepted an offer from John Hancock Malaysia Berhad dated 9 April 1997 as President and CEO of the company. Subsequently, in 1st May 1997, Mr. John has been appointed as Managing Director of the company. All the terms and conditions for above mentioned position that I mentioned earlier has been stipulated in the Corporate Officers Service Manual. Okay, the problem begin when the member of boards is not satisfied with Mr. John's performance. So based on the board members meeting dated 17 November 2000, the boards proposed that during the upcoming AGM meeting to remove Mr. Ng as director and managing director with immediate effect, and also remove him as president and CEO of the company with immediate effects. The justification of his removal is due to first, Mr. John Kim Hong is unable to meet the KPI, to meet the business target to achieve company objective, and secondly is the share price keep continuously drop, which is not favorable to the company. Subsequently, the company, in this case, which is John Hancock Malaysia Berhad, notified the KLSE and the claimant pursuant to Section 128, Subsection 2 of the Companies Act 1965. Fair enough, in the 5th January 2001, the real AGM was held and the proposed resolution were passed by majority votes. So, the impact of this dismissal, of course, Mr. John not happy and he made representative to the Director General of the Human Resource for Industrial Relation under Section 20 of Industrial Relation Act 1967 on the basis that he considered his dismissal from his position to be without just cause or excuse. So John Hancock tried to make a reconciliation and settlement of the court. However, the settlement could not reach. As a result, the Director General notified the Minister. On 21st February 2002, the Minister decided to refer the claimant representation to the Industrial Court and award pursuant to the Section 20, Subsection 3 of the Act. On April 2002, John Hancock Life Insurance Berhad filed an application for judicial review in the Kuala Lumpur High Court and for an order that all proceedings against the company in the Industrial Court be staying pending and final determination of this proceeding for the application for the substantive relief. The ground of relief used by the company is based on Section 128 of Company Act 1965, whereby all the shareholder no longer trust Mr. John Kim Hong as a director, president, and also the CEO of the company, or to lead the company any longer. So issues of the case, I put it in the chronological event. It started in 1997, as I mentioned earlier. Mr. John Kim Hong has been appointed as CEO, president of the company. and he received basic monthly salary 25K from John Hancock. In 1st May 1997, Mr. John has been appointed as director of the company, and all the terms and conditions as all for the position that he hold has been specified in the Corporate Officer Service Manual. However, dated 5th January 2001, the shareholders in John Hancock Life Insurance Malaysia voted in AGM to sack the company's president and CEO with immediate effect. Okay. Subsequently, Mr. Ng managed to take his case to the industrial court, and he is suing the Malaysian company and also John Hancock International Southeast Asia up to 15.8 million US dollar. Dated 21st February 2002, the Minister of Human Resources decided that to refer Mr. Ng's case under Section 20, Subsection 1 of the Industrial Relations Act 1967. Dated 23 April 2003, at the conciliation proceeding, the applicant, which is John Hancock Life Insurance Malaysia Berhad, submitted a written representative and raised the serious concern as why Mr. Ng should not be referred to the industrial court due to the Mr. Ng is he is the workman within the meaning of Section 20 of the Act 1967. Okay, secondly is whether the second respondent, which is in this case is Mr. Ng, John Hong Kim, having been removed by way of two resolution passed at the AGM. So all the shareholders vote to remove him. And then dated 7 December 2006, the Court of Appeal Judges Putrajaya ruled and awarded Mr. John Ng Kim Hong. It should be decided by the industrial court. So the issues here is whether Mr. Ng is an employee of the company or not. So this is the background or the ground of this case. So the judgment of the case, first, in summary, the Court of Appeal decided that the minister, which is the Kementerian Sumber Manusia, is under the purview to consider or to decide whether the case should be referred to the industrial court or not. And then according to the judge, betul lah that memang the duty of the Kementerian Sumber Manusia memang to decide, to analyse and also to decide whether any specific case should be referred to the Industrial Court of Malaysia. So the judges also referred that the removal of claimant from the respective position was by members exercising their right to vote in the AGM is actually memang dalam memang the task of the shareholder memang kerja dia to vote lah. So dia tak argue on that. However, under Section 20 of the Act, the Industrial Court can only adjudicate on a dismissal between a workman and an employer. The employer of the claimant is to be taken as the company of assumption that the claimant is a workman, and which is not in the case. So the court said that the industrial court would be right to decide whether the claimant is to be here at the industrial court. So in addition to that, the judges further explained the definition of workman as follows. Workmen mean any person including an apprentice employed by the employer under the contract of employment to work for the hire or reward, and for the purposes of any proceeding in relation to a trade dispute include any such person who has been dismissed, discharged, or retrenched in the connection with or as consequence of that dispute or worse dismissal, discharge, or retrenchment has led to that dispute. This is the definition of the employee. As such, the judge of court appeal reintegrate that Mr. John Ng Kim Hong was correctly exercised his discretion under Section 20 of Industrial Relations Act 1967 and subsequently ruled in order to refer the claimant's representative to industrial court for an award. So the Court of Appeal of the view that the company may, according to service manual, terminate the claimant employment as corporate officer or officer by giving him 2 month notice cannot be immediate effect. He can terminate Mr. John, but must follow the service manual. So this is the issue, the real issue, whereby Mr. John Hancock has been terminated immediate effect. By right, according to the service manual, he should be given a notice 2 months in advance with the salary. Okay. As such, the judges of the view that it is irrelevant that the claimant was removed by the way of an ordinary resolution at the general meeting, wherein members of the company unattended and voted. So in this case, memang the judges said that first, Mr. John should be, the case should be here at the industrial court. Second, Mr. John should be given 2 month notice if the company decided to terminate his service. So this is the analysis and critique. So if you are the Chief Human Capital Officer or HR executive, you must understand what is the difference between CEO and Managing Director. Must really understand why the different and also the KPI to terminate. Sorry, it's not the KPI. What is the delivery ataupun the KPI for that particular disposition? For this case is Mr. John Kim Hong. He hold 2 positions: CEO, President, and Manager. Too many posts that he hold for that particular company. So if you are HR, if your staff sued the company in court, there is an impact, which is tangible and intangible risk that you need to take into account and consider. First is monetary and compensation to staff, share price, your shareholder confidence and company image. So if your staff suit you, this is not good for the company. The share price will be further drop, and shareholder confidence also will be reduced, and company image also to the investor also not good. Alright, so if you are the employee, always remember that as employee are the most valuable asset to the company. But if the company terminate the employee without proper management, it become a liability to the company. If your boss and or board of director, you just cannot simply fire your employee. You must read the service manual or refer to the appointment letter of that particular person or of staff. Must understand that under Section 20 of Industrial Relations Act 1967, every employees have a right not to be dismissed without just cause and excuse. This is the very, very critical and very important to understand. Without just cause and excuse. It does not matter how much your salary is, how long you are work, what position you hold in the company. If you think that you have dismissed without cause and excuse, you are entitled to a claim against your employer. It means that we need to have very strong justification to dismiss the employee. Thus, the most common ground where the court has recognized that the employer can dismiss the employee are misconduct. So misconduct also, very subjective. Misconduct by employees such as corruption, negligence, this insubordinate also. You must very have strong justification to dismiss your staff. Work performance. In this case, also work performance, not able to achieve them or meet the target. Also very subjective, whether the target is too high or whether the target is too low. Okay. So in this case, for this case, even though the Mr. John unable to meet the target, to meet the objective of the company. But the thing is, you must terminate him within the period that stipulated in the service manual. And also the retrenchment. If the company has no choice to dismiss the employee due to the financial hardship, ni memang tak boleh nak buat macam mana lah. Redundant position during the company reorganization. If the company is reorg and your position is redundant with other person, and then you are in the position high chance to be dismissed by the company. And as an employee, when it comes to applying the law to your case or any particular case, that in this particular case, please consult your lawyer if you have found yourself have been dismissed without cause and excuse. And then I hope that you and me in particular can continue to play our role as most valuable asset to the company and work that we work. So this is reference that I use. Okay, thank you very much, Dr. Shanawi. Assalamualaikum warahmatullahi wabarakatuh.